No, I'm going to second. Another
I have three. What do you prefer?
No, if there are three.
I have three. What do you prefer?
Okay.
Or we just play a lot. This one for Soko. This one is for police officer. What do you call it? Statement. This one is for ICO. You choose one.
I think the sequence is important even for you from the prosecution point of view. The police, the IOs last.
So,
and then you can have a
going by this choice. This time, I'm going by your choice. Say that go with this one. What exception? This is so. So after this one,
but then the storage from that one. I was drawing on my 17 years. I was drawing on my 17 years in two different countries.
which other country?
No, for the city.
You went to
This one became for Uganda.
And the policeman.
Yeah. He was CID officer, CPS. When Kanyamba was also CPS. What became over. Professional people. Very professional. Yeah, there are many. Many who are. Who? Oh, Professor.
So the president came.
Those are the objections. Yeah. Good for about property. Will be another content. But I agree with you. The first big one is civil resolution.
We have
The medical people. The best family. Neither is not easy to know the cause. Morning, madam. How are you? This one, oh, I see. I'm sorry. I'm sorry.
All of that field.
The laptop is not yet here.
The white smoke.
That's the white smoke.
I don't know, an assessor is not visible.
Not visible. There's the white smoke. The white smoke is now here.
Is that from here?
Have I become that dark? You can't even see me now. Where's my phone?
People
that happened. That happened.
What is
No, I have not. That was Trump.
A lot for the record, I will lead PW19. My name is Jonathan Morgan. You switch on the microphone. Tell court your religion. There's a Quran, if you may take off.
I take it written and police solemnly affirm that evidence I shall give, that he matters before court shall be
Your full particulars again.
detectives written and of police. I'm a regional state officer.
We shall ask you.
Rashida Naluzde.
You can adjust this so that you are height. Miss Rashida, how old are you?
I'm 38 years old.
What do you do for a living?
I'm a police officer.
Where are you attached now?
I'm attached at Usoga North Region sitting at Kamu.
Usoga North. As who?
As the regional state officer.
How about by January 2024?
By January 2024, I was a divisional CID officer at Queen Police Division.
What role did you play in the matter before court?
The matter before court, my lord, I was assigned to interview and record a statement from Mole Katanga.
Tell court how you came to be assigned. When were you assigned and by whom?
In November 2023, I was called by the Deputy Director CID, Senior Commissioner of Police, Chelimo Biata, and instructed
Cherimo.
Biata instructed me to proceed IHK hospital and interview the suspect who was there at called Mole Katanga.
Yes.
She told me that I would be picked by the then commissioner, Child Homicide Department. Detective Senior
By the then
Commissioner, Homicide Department, Senior Superintendent of Police, Kung George,
the name again.
Senior Superintendent of Police, Kung George, Kung George,
Yes.
Kung George came at picked me and we proceeded IHK. For the task that has been assigned to me by the deputy director.
Yes.
IHK, I found there at the then district CID officer on Ginger Road. Lieutenant of Police Akong Viviana.
Yes.
She had her team. Also found there.
She had her team. Yes.
The then command CID or commander CID Agarabo, among other people.
Yes.
I of IHK, the officers, and introduced ourselves. The administrative assistant over there. Also detailed
Introduce yourselves to
the administrative assistant at the reception.
yes.
They also told her why we are there, which was to interview more katanga. We got her statement.
Yes.
The Lord, the administrative assistant told us that let her call the attending doctor. Indeed, she called the male doctor.
For the attending doctor.
Called the male doctor.
Yes.
Who came and we equally introduced ourselves and the reason why we are there.
Yes.
The doctor led us to one of the rooms of the hospital.
Sorry. Witness to us. We don't have a statement. We don't really know whether she made a statement. Very strange operation. You know nothing about? No statement. She was not discussed. Nothing. If she made a statement, we would want to have the statement.
My Lord, the particulars of this witness were fully disclosed to the defense, and they exist on the statement of Mori Katanga. She appears there with her full particulars, including her telephone contacts. So the role played by this witness is well known and documented in the exhibit disclosed to the defense.
No. No.
You don't know about the witness was not disclosed and you didn't receive.
She's mentioned somewhere.
In Mole Katanga's statement.
And so what about what she said?
What she has said so far. It is unknown to us.
So did you disclose the statement?
My lord, we disclosed Mole Katanga's statement.
No. She's not your witness. She's not your witness.
My lord, may we understand the gist of the objection so that we can.
I would like to understand.
My-
She recorded the statement.
Yes.
Of the witness and the particulars.
And
So how would she not be a prosecution?
She needs her own statement.
She needs her own statement.
Yes.
What
She said.
another witness or another person said is not her
No,
business.
she's testifying about what she did.
Yes.
But we don't know it until now.
She's telling us what she did.
She's told us, my lord.
So far, what she has told us that she did is that's what she's testifying.
It's not in More Katanga's statement. What she has said so far is not even in More Katanga's statement. Her
But that
statement
is what she's
sprang
telling us
to
that
us.
she did. She's not testifying now about what is done.
My lord would want to cross-examine her, perhaps. I don't know.
You want to cross-examine her
on her own statement, not on another person's statement.
What she's telling us what she did. You cross-examine her on what she's testifying that she did.
My lord, if this, your lordship, with greatest respect, if this was a magistrate's court, that would be perfect. And I must have a statement as a defense lawyer before the High Court, before the witness for the prosecution starts testifying.
If he's an expert.
My lord,
And my lord, if I could just supplement. My lord, the witness has spoken about events of November 2023. Mole Katanga's statement is January 2020. So even what she's saying now, certainly the end of the story we are hearing does not end in Mole Katanga's statement in November 2023. So whatever she was doing in November 2023, we need to know it. We don't know it. We don't have a statement from her. Even if she had recorded, for example, a charge and caution statement, the practice is clear that even that officer would have to record the statement. My lord, it's especially more important when you're dealing with an alleged statement from an accused person that you want to use against them.
Mr. Morgan, did this witness recorded? Did she record her own statement of what she did?
my lord, she did not, and she did not record one. My lord, let's get this clear. Mr. Kabasi is submitting that if this was a magistrate's court, it would be okay. Yes, if. But in the High Court, she must have one. And unfortunately, my lord, he has not given us the benefit of benefiting, the leverage of benefiting from the basis for that. Is that what the law provides? Is it a matter of practice, as Mr. Karuhanga puts it? Is there any law that precludes a witness that recorded a suspect's statement and disclosed her particulars thereon as the recorder? And the statement is so recorded, it was disclosed, and it is apparent that it was actually recorded by that witness. Is there anything that precludes such a witness in law from appearing in court to testify as to what she did? My lord, just
Let him finish and we'll respond.
my lord, the rest of the background information certainly has to be given before, because a witness cannot just dive into the statement all of a sudden. We get there. So what the witness is doing now is simply to give the background information as to her instructions.
My lord, that's trial by ambush.
My
lord, the principle of fair trial is disclosure of evidence. A witness cannot appear who we have never heard about, telling us a story about events we have no idea about in November 2023, being told that she's going to tender in a statement of January 2024.
So the witness is the one who recorded that statement of the accused person. And she's laying a background of what transpired leading to the events of recording the statement. And the statement was disclosed.
Yes.
The statement
with her
both sides
particulars
have, with her particulars.
as the record.
Where is the ambush?
My lord, that's a total ambush because the background that she's laying is a subject we should be able to cross-examine on. My lord, the law regarding recording statements from accused persons is very clear. There are even rules on evidence you record from accused persons. There's a constitutional court decision on rights not to self-incriminate. What we are talking, and I'm not even saying that's what's in her statement. My lord, what we are saying is quite simple and clear. We're not even saying she can't testify. No, we are simply saying that any person who comes to this court either has a statement they have disclosed of what they did or a forensic report upon which they have done their work. A person cannot come out of the blue and all of us start hearing what she's saying and then we all stand up to cross-examine her. More so, if this person's intention is to tender in a statement made by another person. My lord, in every case, a police officer who intends to tender in, even if it were a charge and caution statement, comes to a court with their own statement. My lord, what we are telling what they did. My lord, what is before you is an officer making her statement. And my lord, that is trial by ambush. For us, my lord, it is our submission that the fundamental right to a fair hearing includes the right to disclosure. You cannot tell me that I gave you a phone number. My lord, if I had even dared to ring that number, that would be interference with the witness.
The witness is closed. I mean, the prosecution is closed.
Mole Katanga statement.
Which was recorded by
Ah.
Yes. She's the one who recorded.
Yes.
And she stated her particulars.
Yes.
And it is known that she is the recorder.
Yeah, she's the
Just
recorder.
my lord, that way. But my lord,
She's giving evidence about what happened 2 months before she recorded her statement.
She's laying the background to how she came to write the statement.
My lord, we don't know that background of November. If she had said, I went to the hospital in January and I recorded Mole's statement,
And ended there.
But first of all, she's telling us about so many different people who are involved. My lord, there is no statement in November 2023.
No.
It doesn't exist. The evidence of this witness is about events that happened in November 2023. Unless the court can rule that she limits herself to the statement disclosed of January 2024. But if she intends to read the background of November 2023, we don't have that background.
But the statement did not just coming from a vacuum. She's telling you how the instructions were received, how she proceeded to IH.
In November.
How she was introduced. Yes.
My lord, in November, there is no statement in November.
The statement is
The statement is January. My lord, this is our
my lord,
problem.
may I propose?
So unless she's going to limit her, if this court is of the opinion that the statement is what is important and that it was disclosed, then she must limit herself to what was disclosed to us, which is the statement.
She say, I came, I recorded the statement,
Yes.
and went away.
But
That's
otherwise, if she's telling us things where we don't have a statement of November 2023, because what she's talking about is people who were present in November 2023. My lord, we have no idea about anything that happened in November 2023. Certainly, that story does not end in a statement.
And it is not in the Maureen statement.
Mr. Kalwanga, my lord, may I just propose? We are here so that we can guide the court. May I propose that the defense makes a formal objection because they are speaking to the law. My lord, they should traverse that law, guide the court. Then we make a formal response and the court makes a formal guidance. We actually came prepared because we know there are authorities that support what we are doing. But we are at a loss when our land brothers keep saying the law, and they are not citing it. My lord, may I propose that they make a formal application and then we make a formal brief reply and then we can be guided and then let Mr. Kalwanga guide the court on that law which is supporting his position. Then we can reply and move on.
even come with authorities.
My Lord, we've already made the objection, which is that we do not have a statement of this witness, prosecution witness number 19. We don't have the statement of that witness. We do not have to be so fanatic. For everything we say, we quote the law. We are officers of the court. Expedition of the trial is an important tenet of our jurisprudence. We do not have to waste time all the time for every statement we make. We quote the law. Of course, we can do it, but that will take forever. The law requires that the prosecution discloses the statements of witnesses that are required to be called, so that the defense can adequately prepare for a fair trial. It cannot be fair for suspects or accused persons to sit there and we keep on springing things at them which they know nothing about. Yes, we may know that this particular witness recorded a statement from A1. As suggested, we shall not object if only that is presented. But anything beyond the act of recording the statement, we need information about it. So we object to this witness testifying on anything other than the act of recording the statement from A1. Otherwise, my Lord, we would apply for a statement to be furnished to us covering the period is already started on, and the people and the areas and so on of the events of November 2023. Comes and says, well, I'm so and so, I'm the one who recorded the statement. That we have no objection to. Beyond that, we need a statement.
You alluded to the law and to authorities, Commission.
My Lord, the decision of Sun, is it Sun Kong versus the Attorney General is instructive on that disclosure of statements must be made. My Lord, with regarding evidence of accused persons, but we've already made that concession, so I need not push that point, that insofar as her evidence is limited to recording a statement in January 2024, we have no problem. But my Lord, insofar as they intend to tell us a story that they have not disclosed to the defense, we cannot be hearing it here, my Lord. It can't be. And my Lord, and we pray that what she has said on the record be expunged from the record, was not disclosed to the defense, and that she limits herself to the events of January 2024 when she recorded a statement of the accused person. If they want, they can even show us that statement and we see if we even have no objection to it. But then that's another matter for the reading. But my Lord, our contention is that you cannot tell a story that hasn't been disclosed. It is, and if you do, it is a violation of the non-derogable right to a fair hearing. What is fair about being ambushed? And if anyone, if the prosecution can show us where we have that story of November 2023, which they've disclosed, because what she has said so far is not in Mole's statement, it's not in Mrs. Katanga's statement.
My Lord, the objection as we understand it, that the defense is not comfortable with the witness testifying because she has no statement disclosed. My Lord, is not in dispute, and it has already been highlighted by the witness that her role and her purpose of appearance is to speak to her particular role of recording a statement of More Katanga. My Lord, it is not also in dispute that the statement that the witness recorded was fully disclosed to the defense.
Witness.
And that statement bears the full particulars of the witness on the stand as the recorder. I know the disclosure of the document in form of a statement that the witness authored from More Katanga provides sufficient information what she did. Ordinarily, the authors of documents appear to speak to the documents that they authored. There is no requirement that they record separate policy statements. They only appear in court to speak to the documents that they recorded and the circumstances under which they recorded the same. I note the preamble being given by the witness of 2013, of 2023, is merely background information as to how she came to be instructed to play the role that she played. My Lord, there is no law and I want to agree with the defense when they fail to cite any. Indeed, there is no law that precludes a witness of her circumstances from testifying on the basis that she never made a personal policy statement. My Lord, this matter, similar objections have been handled in several authorities. In the interest of time, my Lord, I will refer you to two. one persuasive decision by His Lordship Stephen Mubiru.
Can we have a copy?
My Lord, it's a criminal revision application number 3 of 2018, Uganda versus Okumurigan and 5 others. My Lord, in this case, the magistrate dismissed the testimony of an investigating officer on the basis that he never recorded the police statement. My Lord, the DPP appealed that decision by way of revision to the High Court. And on page 3, my Lord, paragraph 10, the argument of the prosecuting counsel was that there is no legal requirement, that there was no legal requirement that a prosecution witness must have recorded a statement at police before he or she qualifies to testify. And that the actions of the trial magistrate of declining the testimony was unlawful. My Lord, on page 12, the court had this to say.
Paragraph?
Page 12 from the second paragraph, after line 5, that disqualifying witness testimony is a severe sanction to be imposed only after careful consideration. That precluding evidence because of its apparent or anticipated or supposed lack of credibility is not an option available under the Evidence Act. My Lord, the judge continues, but you'll find on line 13 that a trial court has no special inherent authority to exclude witnesses based on their apparent or presumed unreliability. My Lord, it was the argument in this matter, it was the argument of the respondents, the accused persons, that a witness that appears without a police statement, his evidence should not be considered by court because it would be unreliable. No. etc. But on line 15, His Lordship emphasized that it is for the court to determine the veracity and weight of the testimony. That the proper method to use with such witnesses is to let them testify and allow the adversary, through cross-examination, to inform the court about the circumstances casting doubt on their testimony. So, my lord, you can see that even for the reasons being advanced by the defense about the background information, etc., the defense must listen to the testimony, my lord, and test it through cross-examination. And the witness, my lord, is present in court. And there will be an opportunity to cross-examine. So, my lord, we pray that this court be persuaded. This issue was squarely addressed. Same objection of exclusion of evidence on the basis of non-recording of a statement. And this is the position of the High Court, for which we pray that you be persuaded. But, my lord, there is perhaps a more compelling decision of the Court of Appeal, for which we still pray to draw your attention. This one, I don't have an extra copy, but I can share electronically because I have it here.
Give us the copy, then you share with the court.
Appreciate you don't have to. Karuhanga shared it with you. I've shared it with Mr. Kavek as well. Yeah. Shared it electronically. My lord, in this Court of Appeal decision, which is a criminal appeal number 85 of 2018, the case of Odere Patrick versus Uganda. And what you find on page 35, which addressed ground 3 of appeal, which ground was an objection relating to failing relating to the criticism of counsel against a police officer who testified not having recorded a statement. And what you find after line 890, and for the record, allow me just to read it, the objection as it were. My lord, the court noted that in his submission on this ground, counsel for the appellant criticized the investigating officer PW11, Detective AIP David Mapera, whom he termed as a supposed investigating police officer and only police officer who testified. And that is quoted, my lord. So, for having no police statement of his record, having no police statement of his on record when he testified on the 28th of June 2016. My lord, the contention in this matter, what counsel was contending with, is that an investigating officer was called, testified, had his evidence on record in the absence of his personal policy statement. My lord, on the next page, 36, the first paragraph, when that objection was raised, the reply by the state, I will just read it verbatim again. In reply, counsel for the respondent, I know the respondent was prosecution, submitted that there is no legal requirement that for a witness to testify in court, he or she ought to have recorded a statement at police, among others. And my lord, that is our argument here as well. Now, on the next paragraph, this is what the Court of Appeal held. And my lord, the Court of Appeal was quoting the position of the Supreme Court in the case of Chemonges Fred versus Uganda, which is Supreme Court Criminal Appeal number 12 of 2001. And it held that whereas it is desirable that witnesses record statements during investigation, these statements are mere guide on the nature of evidence the prosecution intends to rely on. They cannot be considered as substantive evidence, as such statements are neither made during trial nor given on oath or tested by cross-examination. And my lord, the court held that the courts will always prefer the witness evidence that is tested in cross-examination, and they made reference to the locus classicus decision in Chemonges. In a nutshell, my lord, so you find in the last paragraph, my lord, on page 36, the court accepted the respondent's submissions that in the context of the case, the police statements were largely to enable prosecution to identify the appropriate criminal charges to prefer against the appellant, and the defense to have a picture of the evidence to be produced against it during trial in order to prepare appropriate defense. And ground 3, my lord, which was contesting the testimony of a police officer without a statement, accordingly failed. In summary, my lord, there is no law that precludes a witness testify merely on the basis that they never recorded a personal statement. Number two, statements are merely guides to give a picture to the prosecution of what offenses to prefer, and also a highlight for the defense as to the nature of evidence to expect. And my lord, in this case, it is even better, because the evidence that this witness took from the accused person is well disclosed. They can't be tried by ambush. The information is disclosed. It can also be said that we are offending any rule relating to disclosure, as put in the case of Sun Yang, because my lord, disclosure was actually made. She is not a surprise witness because her particulars are clearly on the document so authored. So my lord, like in the two cited decisions, we pray that the objection is overruled for lack of merit.
Objected, you have responded, you have replied.
My lord, could this apply to the appeal with the decision you last relied on? Do you have the hard copy?
No.
Please, my lord. My lord, the primary issue before this court is whether a prosecution witness can appear in court and give evidence which evidence has not been disclosed to the defense. And my lord, two authorities are cited to support the proposition. The proposition that a proposition that waters down the requirement of disclosure. First of all, my lord, in the Odele Patrick case, the witness had actually recorded a statement. My lord, this can be found at page 'cause as I'm finding it, the facts of that case as I know it, are that the witness had actually recorded a statement. And the issue which the court was relying on was whether all those statements need to be exhibited in evidence. The Odele Patrick decision at no point talks about pre-trial disclosure or disclosure for that matter. And my lord, in particular, we are dealing with ground 3 of the appeal, which is what my learned friend has cited. If I could get a minute to that case. My learned friend is using that case to say that Statements are simply guides to the prosecution on what charges to prefer. My lord, whatever is guiding the prosecution should be disclosed. And whatever the prosecution has, whatever story, because the prosecutor is right now leading evidence on a story that he has been told, and that's why he's leading that evidence. My lord, at page 35 of that decision, counsel for the appellant criticized the investigating officer, DIP David Mapera, whom he termed as a supposed investigating police officer, and the only police officer who testified, for having no police statement of his record when he testified on the 28th of May 2016, and that he never exhibited any charge and caution statement, but that it was only when the defense asked him for his police statement that the same was tendered in as Defense Exhibit D9, because the prosecution had dodged doing so. And he didn't know the ingredients of the offense he was investigating. Counsel submitted that there is no legal requirement for a witness to testify in court, and that there is no time limit within which the witness statement can be recorded. Now, the decision of the court, my lord, was that witness statements are not evidence. Police statements are not evidence. It is the evidence they gave in court, which is also the position of Chemonges. My lord, none of those address the cardinal right to a fair hearing. The cardinal right to a fair hearing is that the prosecution must disclose all the material it intends to rely upon. All of it. My lord, the decision of Chemonges, even the holding in that decision, has nothing to do. The issue was not whether a statement should be disclosed or not. In fact, in that case, it was disclosed. In that case, it was disclosed. And he was accused of hiding it, but it was disclosed. And what the prosecution is saying right now is that they can bring evidence about circumstances they haven't disclosed. My lord, the record will reflect very clearly that what this witness has testified does not appear in the statement of Mrs. Katanga. The witness has told this court that she went to IHK Hospital on a date in November 2023. She met there Mr. Kagabra. She was picked by Mr. Mpungu. She met Mr. Kagabra. In November 2023, she approached a hospital attendant undisclosed in November 2023. And that hospital attendant, that is when we objected. You know, that evidence. She found a divisional CID at Congo Bibiana. None of that evidence is before us. It certainly doesn't appear in Mrs. Katanga's statement. And it would have even been excusable. But the fact of the matter is that even on that date, undisclosed date in November 2023, there is no statement. The statement of Mrs. Katanga is dated January 2024. Is the authority for Chemonges? Can the Chemonges authority, can the Odele authority, and can the Uganda versus Okumuregan authority be authority for trial by ambush? Can it be authority for a prosecution bringing a witness to tell a story that they have not told the defense? My lord, the prosecution, respectfully, throughout this trial, treats pre-trial disclosure as a favor being extended. My lord, there is no favor in pre-trial disclosure. Quite the contrary. Pre-trial disclosure is a right. It is a right that an accused person is entitled to. It is a right long established in our courts. As the defense has said, if this witness's evidence is limited to what was disclosed to the defense, i.e., that she recorded a statement, if it is limited to that statement, that is one thing. If it is speaking about circumstances, the argument that it's curable by cross-examination respectfully is, I'm looking for the respectful word. My lord, wishes to elicit testimony from a witness that he didn't disclose. That is an underhanded prosecution. It is I'm just following up on authority. Again, my lord, given the circumstances of the application, the prosecution comes to court with authorities well knowing that it is intended as an ambush. And clearly, my lord, as I'm getting at authority, if I can go quickly to the Okumuregan authority. Again, Okumuregan is not authority for not disclosing at all. Certainly is not, it's certainly not authority for not disclosing. The decision in Okumuregan, my lord, is that pre-trial, on page 8 of that decision, it says that pre-trial disclosure of witnesses to be called is a means of discouraging and exposing fabrication, inaccuracy, and collusion. The public interest in the orderly conduct of criminal trials is sufficient to justify the imposition and enforcement of firm, though not always inflexible, rules relating to the identification and presentation of prosecution evidence. All should be geared at satisfying the public interest in a full and truthful disclosure of critical facts before trial. To be effective, the principle must be applied with equal force to the prosecution and to the accused. So, my lord, my lord, my landlord asked me to repeat, so let me repeat. The public interest in the ordinary conduct of criminal trials is sufficient to justify the imposition and the enforcement of firm, though not always inflexible, rules relating to the identification and presentation of evidence. Now, my lord, you also realize that this is a revision from the decision. My lord, I think this is the one they had supplied to court. This is not the one they had supplied to court. This is Okumu. I'm reading Okumu at page 8. I'm still using it. I'm still using it. So, my lord, at the heart of this dispute is simple, plain forward constitutional law. Is simple, plain forward the right to a fair hearing. And that right includes the right to pre-trial disclosure of all evidence the prosecution seeks to rely upon. If My Lord, if the prosecution can be allowed to introduce evidence through the back door, claiming that this is disclosed by her writing her name on Mrs. Katanga's statement. Therefore, they have disclosed to us that she went in November 2023. Then there's a total mockery of fairness in criminal trials. My Lord, the defense would have been entitled to know what happened in November 2023, what she alleges happened in November 2023. It would have been entitled to cross-check what happened in November 2023. It would have been entitled to interview, certainly, its own witnesses regarding events in November 2023. It would have been entitled to know, for example, which hospital attendant was present in November 2023. But to know fully well that they intend to elicit this information, to have it, to start leading it, that opens room for unfairness and, frankly, for fabrication. And to say that you have a right to stand up immediately after and cross-examine is, my Lord, an incredible, incredible prayer. My Lord, my Lord, I'm looking to quote for you some provisions of the decision in Son Kyung. And also, my Lord, I apologize for the difficulty in immediately getting the authorities. As my Lord will see, my learned friends came knowing because an objection will come. They came prepared because, like anyone on an ambush, they came prepared. My Lord, there are a number of authorities, and I just want to rely on some of them that I pray are more persuasive. On disclosure. My Lord, the primary requirement for disclosure my Lord, the state must disclose all material which is known or possessed on which ought to be disclosed. That is the law. And from it, there's a Kenyan decision, my Lord, I'm going to cite it shortly, but it's saying that the plain reading of the duty imposed upon the prosecution is to make available all the evidence in their possession to the defense without restricting the same Full disclosure is neither restrictive nor conditional. Prosecution should not be made to withhold some evidence which it intends to use in the trial from other accused persons. Prosecution of a criminal case is like a web. What may not directly touch on the accused can indirectly or circumstantially connect or touch on any other accused person. To restrict production or supply of information or evidence will go against the spirit of full disclosure of evidence to the defense, contrary to what is envisaged in the Constitution. The accused persons are not going to be overburdened by reading the prosecution evidence. The court then says, it's a revision application, my lord, that I'm quoting. The decision I'm quoting, my lord, is a revision application in the High Court of Kenya at Nairobi, in Peter Aguko Abok. In the DPP versus Peter Aguko Abok shall supply.
How does he need to share that new authority?
Well, I'll forward it to him. Unlike him, I came into an ambush. Huh? So I will share the authority.
Versus
Peter Aguko Abok, which was in the Kenyan case of revision application number 42 of 2019 in the High Court of Kenya.
42?
Yes, of 2019. Now, it was dealing with disclosure as per count, but I think the essence of disclosure, they say, was aptly captured. An accused person, this is at I'll send it to you. But if I can continue, I'll send you the authority. Every charge, and it says that it is trite. The right to be, they then quote, in that case, they quote the case of Itui Mwangi and two others. The right to be provided with the material the prosecution wishes to rely on is not a one-off event. The disclosure of evidence, inculpatory and exculpatory, is dealt with as the duty to provide the material is a continuing one.
What's the case of
Tuita Mwangi, Thuita. For basically stating the general principles. But the general principles, though, my lord, are more fully and elaborately set out in our Court of Appeal decision of Sun Kong versus the Attorney General. And also in the Kenyan case of Juma, which was relied upon by the Constitutional Court. And in that case, my lord, in the Constitutional Court provided in Uganda that an interpretation of Article 28 of the Constitution, which provides that an accused person shall be accorded all the facilities to defend themselves. That facilities means the resources, the convenience, and the means which makes it easier to achieve their purpose. The unimpeded opportunity for doing something favorable to them. And they say that that is a full and open access to the prosecution case, so that the prosecution does not gain an unfair or undeserved advantage over the accused, so that the accused is not impeded in any manner, so that the prosecution does not suffer any unfair advantage and prejudice. These provisions of the Constitution, our Constitutional Court said, can have life and practical meaning only if an accused person is provided with copies of statements made to the police by persons who will or may be called to testify as witnesses to the prosecution. as well as copies of exhibits which are to be offered in evidence for the prosecution. In an open and democratic society, this is the Constitutional Court of Uganda quoting the Kenyan court in Juma. In an open and democratic society based on freedom and equality within the rule of law as its ultimate defender, such as ours, the package constituting the right to a fair trial contains in it the right to pre-trial disclosure of material statements and exhibits. In an open and democratic society of our time, courts cannot give approval to trial by ambush. And in criminal litigation, the courts cannot adopt a procedure under which an accused person will be ambushed, subject to the rights of every person entrenched in the Constitution, including the presumption of innocence until proven guilty beyond reasonable doubt. The fundamental right to a fair hearing by its nature requires that there is an equality between the contestants in litigation. There can be no true equality if legal process allows one party to withhold material information from his adversary without just cause or peculiar circumstances. So, my Lord, the Constitutional Court has set out two criteria: just cause and peculiar circumstances. And my Lord, they are saying there is no greater unfairness, than for one, there is no greater attack even on the presumption of innocence and the rights enshrined in the Constitution. There is no greater inequality if one party can withhold material information from his adversary without just cause. My Lord, in this case, Mr. Mwaganya is in possession of information that that witness went to IHK in November 2023. That is not information that anybody on the defense side has. That is not information the accused person has. Mr. Mwaganya and my learned friends are in possession of information of who she interacted with. That is not information we have. The requirement, he says there's no requirement for a statement. The soon decision is the one, my Lord, that is instructive. For him not to disclose her statement, there must be exceptions within the decision of soon. The soon decision, my Lord, is binding on this honorable court. Yes.
I think this is becoming law. Let me propose a reform.
Yes.
Let us have submissions. Many cases are being written submissions. Many cases are being cited. Court has to also look at this in totality, because we don't know what is being picked, whether it's being picked up from context or not. We need to have submissions. But in the meantime, we can continue, and then when the submissions come out, and whatever is found to be contrary to the ruling will be expanded.
My Lord, can I make an additional proposal with you? My Lord, I pray that instead this witness be limited to the events of January, and then if we have to go back to the events of November, you first make a ruling on that, and then we put it on the record. Because the prejudicial effect.
We will expand it if it is against the ruling. With the number of authorities being voted, and the nature of the submissions, and the impact of the matter, I think we owe this court submissions. And the copies of those authorities are going to give you schedules that she's going to proceed, and if the ruling comes out that something has to be expanded, it will be expanded and it will be placed on the record that that part of it is expanded.
Much obliged, my Lord. Thank you, my Lord, for your wise guidance.
Much
obliged, my Lord, much obliged.
My Lord, in the meantime, may he return what material?
No, my Lord, supply them with submission.
My Lord, I want to read it.
Yeah, but
I want to read it in full.
electronically.
They serve very good.
Yeah.
You can't print. You cannot send.
Much obliged, much obliged.
Thank you, my Lord. Where we ended.
But the schedule for the sub.
Oh, okay.
It's not.
Hello, today is 19th.
No, you just need 2 days each.
2 days.
Yeah.
Yes, applying the authorities, I think. Usually,
One day.
one day,
Well, not 1 day.
1 day should be enough. 1 day each. 1 day each.
For this,
For the submissions.
they say they can submit in 1 day. To the authorities.
Can send you on Monday, then you respond on Tuesday, Wednesday.
Give you Monday.
Come on. Okay, Monday.
Monday.
Oh, close of the.
So you can prepare. Have the whole weekend.
Yes. So that
Monday.
Then for you, if we give you today, you file it tomorrow.
on Monday.
So why are you fearing?
Monday.
So my lord, we
Monday.
can do Monday, then they do Tuesday.
No,
Okay.
my lord, today is Thursday, so they will have 4 days, and then we can't have 1 day.
The weekend is not counted.
My lord, if they want 1 day, let them submit tomorrow.
Not today.
Yes.
Then we do it.
Or today, and then we reply tomorrow.
So you're putting ourselves in so much. Yes. Then.
By Wednesday.
Much obliged.
So the defense will submit together with authorities. Monday, 25.
November 1st.
Thursday. The following day, Thursday.
So that will be meeting on. Second.
So that
It's 20.
So-
I don't know, we'll begin with the middle of it. That's not. I see second is Wednesday. So I'm going to start Monday, Tuesday, then the ruling is Wednesday. We'll start Wednesday.
We shall start Wednesday.
we continue, my lord.
Yes. Please.
Madam Rashida, we ended at the point when I was asking you to tell court how you came to play this role in this matter. And you were at a point when you were stating that when the male doctor was called, he led you to one of the rooms.
That's one of the so with the male GPD officer,
What was he doing?
Had a seat there.
Yes.
Seated on the door. We entered with the doctor.
Entered with.
He found him on a katanga. The doctor introduced us and our purpose of being there. If I introduce ourselves, our purpose of being there. They told us that
Purpose and the purpose.
God has death.
That you are. Ought. Yes.
She said that she was unable. Available, she recorded it. Her pressure was
Yes.
communicated back to the deputy director saying this one to the back. Then she instructed me to go back to my duty station, which was then yes, she told me that I can come with me.
Okay. Anything follow thereafter?
In January 10th, 2024,
Yes.
the deputy director CID communicated saying told me that Ole Katanga examined
Yes.
told me to proceed now at IHK. Told me to proceed back to IHK. Interview Ole Katanga.
Yes.
Went to IHK. On arrival,
On arrival. Who did you meet?
The divisional state officer of Ginger Road there. Superintendent of police.
Yes.
I also met there the then regional state officer. Yes, superintendent of police. Then regional state officer of KPs.
The name?
Senior superintendent of police were home very soon.
Yes.
I also met there two gentlemen who introduced themselves as lawyers. One of whom told me
Are they in this court?
Of course they are.
Who are they?
one of them is
Lawyers identified.
I also found there a nurse. I introduced myself. The parties I had met at uni. Purpose of being the hospital.
Yes.
I was late to the room where only katanga was. The nurse said to me,
Yes.
in the room, and to get to remember they introduced. I equally went inside with the then divisional state officer.
You went together with, in the room with Aton. Yes.
In the room, Council Judge introduced us for katanga. Our purpose of being I equally introduced myself to her. I also
You
told her why
equally, we are writing. Equally introduced.
myself.
Yes. In what language were you communicating with Molly?
We are communicating in English.
Why did you choose English?
On entering the room,
What followed?
what followed, I asked her her particulars.
Yes.
I asked her questions in line with.
And when she availed the particulars, what did
I
you do?
recorded them. Date sheet.
Yes.
gave me an account. She gave me answers to this. I recorded whatever she had given me. Sheet of paper. Sheet of paper. Recorded.
Okay. After you recorded her account of events, yes. Yes.
After reading, he read the same content, client, back to the client.
Yes.
You had to look about the sheets of papers. And I read about the same content.
Okay.
Thereafter,
After you read back to her, yes.
what katanga asked, what have I stated well?
Who was she asking?
She was asking her counsel. Counsel replied to her, it is your statement. He then signed 4 pages of her statement.
Yes.
Then consulted for the demand side of 4 pages of the statement. Signed for 4 pages of the statement.
Why did he give any reasons for demanding to countersign his client's statement?
How can I proceed to change?
After lawyer Jet signing,
I signed the statement. I put my particulars, my names. My employment there. Tax numbers. That's what he is. I am Indiana.
are you in position to identify the statement that you saw recorded? How?
Appended my signature.
Yes.
Must be my handwriting.
Look at the document. That's the statement that you recorded.
My lord, this is the statement that I
It dated. Which date?
stated 10 January 2024.
Just a minute. What time did you record it?
The statement was recorded. I recorded it at 17:10 hours.
Place?
It was recorded from IHK Hospital.
Where did you sign, and the rest of the people that you told court signed?
My lord, the signature on top of the first page of the statement where there is a stamp. Only katanga who signed there. Every page. Yes, from whoever there. Signed beside stamp. He put their own Kampala Associated Advocates. Put contact number 0772.
Let's go slow.
Who's the phone number? Who's the phone number? Are you reading? You can't do that. No?
What did the council yet put against the
Answer
these
yes.
particulars?
He wrote yes from whoever there. Underneath Kampala Associated Advocates. Underneath 077.
No. I cannot read my private number to the public. I don't want to.
My lord, we are dealing with evidence. I don't even know whether that is his number, whether it's
Even
She
if it
says
is
so.
a-
She says so.
there's no provision that we should read
But we pray that you
in
protect
separate.
yourself.
You must protect the bar. It's what you have to do.
He pressed the telephone number.
Yeah, it's there. That's it. Yeah.
Okay, since in my lord,
It is in his writing. so-
and my lord, since council is not contesting putting it there, it is okay.
Yeah. It is my lord. But you can't read it to the world.
But my lord, the prayer, if the prayer is understandable.
Yeah.
It is different when you protest.
So why don't you understand? So underhand. My lord.
So
My lord, underneath
the number is on the statement. Yes.
the number is.
No, don't read the number.
The number is underneath.
The number is
Kampala
underneath.
Associated Advocates.
Okay. And about yourself?
That very page. Page 1. My signature. There all appears twice. In the right tab. The second page, my lord.
Today they all sign on the second page.
Yes, my lord.
About you?
The second page I didn't sign, my lord.
Did the accused sign?
Yes, my lord.
Did the lawyer sign?
Yes, my lord.
Next page.
The third page. The accused signed, the lawyer signed, and my signature. All on that very page.
The next page.
The last page. The accused signed, the lawyer signed, and I equally signed.
That the last page.
Yes, my lord.
First, my lord, we want to tender the document
Can we look at it, my lord?
as an exhibit.
Let's look at it. Yes, what are we like? Yes, yes. We can talk about it. If you need to. Okay.
Perfect. My lord, let's just scan. We left our copy.
In case you were there. I'm saying you can commit it.
No, you're just scanning it before.
Just subject number.
And then you read her own number and it's there. Her own number is there. She should read it. She's avoiding it for her to read now. The public document.
Yes. My lord, for the record, plain statement. Just for clarity. Plain statement.
Yes, plain statement.
Yes, yes. Plain statement. It's a plain statement.
That's it.
Omujulizi ali mu kkooti atugambye gali musiramu amabala ga NWA Naluse Rashida aina emyaka 38 y'obukulu kandi ala rank ya superintendent of police. Yatugamba saa zino akolera Soga North Region Headquarters egekala Kamuli. Yatugamba mu January y'omwaka gwa 2024 akaba nakolera akaba CID regional CID officer nakolera Katwe. Yatugamba bakamu omulimo gwo interviewinga kandi arecording statement kuruga mu Katanga. Yatugamba mu November 2023 bakamuterera esimu akaba Deputy Director CID Commission of Police Chelimo Biata. Yamugamba agende IHK hospital abuze yabenda zimanizibwa kandi amale recording statement. Ayamusomere akaba SSP Mbugu George. Then yagenda Kato yamufuna bagenda Irwaro kukola omulimo gwabaire gwetagisibwa. Bwayakira Irwaro akasangayo SP Akong Bibiana ne team. Then yachora yasangayo Commander CID Kangabo n'abandi. Then bagenda mu reception ya IHK bayebazaho admin assistant. Then bamugamba ekyabali kibaleserawo nti bakani benda kubazaho na Mole Katanga bamale bamwandiko statement. Then ayabaira reception yayeta yayita dokita omusajja yajja yayebazawo kandi bamugamba ekyabali kibaleese. Then ogwo dokita yabatwala mu room naali mole yabe n'atungira obujanjabi kandi amulyango bakasangawo omusirikale omusajja wa UPDF akabaikaliire bata mu room bakasanga Katanga alimu. Then dokita yagambira mole Katanga yabazawo bana mole Katanga, then nabo bamara bayebazawo. Then we ono ali mu koti yagamba mole Katanga nti aisire kumwabuzawo abo akufa kumugenzi Henry Katanga. Then mole yabagamba we yamugamba takusobola kubaza kandi takusobola nokola statement abo kwa pressure yaye kabiri aiguru muno. Bayamazire yatirira boss waye, boss yamugamba garukeyo a police kadwe ayengereyo n'emirimo yaye. Then yayongerayo katwe n'omusirikale wayabaira izire nawe. Ebiro by'okwezi 10 mwaka 2024 musirikale wa Serege Chelimo Biata akamutera esimu yamugamba nti mole Katanga bamukebeire, abadaktari bamukebeire bamugamba nti saa zino akusobola kubaza kandi akusobola kumuyaho statement. Yamugamba agende ha high HK amwabuze deni amukolo statement. Then we yayongerayo ha high HK bayakireyo akasangayo divisional CID officer SP Akong Bibiana na SSP Wathum Benson. Then yatugamba akasangayo na basajja bandi babiri bayebazawo nkaba baloya bakatanga nti omu bamwetaga Kabega ondini bamweta Jet Mwebazi. Yachora yatugamba akasangayo Nance yayebazawo kandi yamugambira n'omugaso gumulesere mwirwaro. Then Nance yakabatwara mu room nali mole Katanga yabaire hano bakagenda na Council Jet Mwebazi. Then bakagenda mu room na Akong Bibiana. We bakire mu room Council Mwebazi akagambira mole Katanga omugaso gubalesere. Then nawe yayebazawo yagambira mole Katanga kimulesere nti aizire mwiyaho statement. Ya atugambire bino byona bakani babibaza mu Rujungu. Atugambire ge habwakia koseze Rujungu chakawura Council Mwebaze na baza na client waye mu Rujungu. Then na mole Katanga yagamba na wakusaba kubaza Rujungu kurungi. Then yamwabuza bimukwatawo byona yabimugambira. Yamugambira amabara ge byona yachora yamwabuza ebikaguzo kandi bayamazire bayabe na mukaguze ebikaguzo oli na mugarukagamu byona nabihandika. Amazire kuandika Council Mwebaze akasaba byabaira handike kandi yakyora yabisomamu. Bayamazire kusomamu yakyora yamugaruza empapura. Bayamugaruza empapura akakyora yabisomeramu mole Katanga. Mole Katanga yabuza mbalize kurungi. Then Council yamugamba aye statement yawe. Then bayamazire ya signinga mole Katanga ka signinga abiru papura. na counsel tumwebaze nawe yasaba asayininge kwetegereza statement egyo eyinaho signature yaye kandi signature yaye kandi eyina kuba mu handwriting yaye. Bamwolekeze statement yatugamba niyo statement ya recordingire nti akagihandika ebiro by'okwezi 10 January nti akagihandika ebiro by'okwezi 10 January mwaka 2024 akagihandika mu kaire ka IHK hospital kandi statement bagitaize mu koti mu rekodi za koti.
Lord, may PX 59 be returned to the witness. You said you asked and Mole gave you her particulars. What particulars did she give you? Microphone, repeat.
Business lady, president of Objection. Our division, our district. Telephone, brackets, who forgotten lines. Who forgotten lines.
What did that mean?
As in to forget. Her answer to what you telephone contacts her where that I have forgotten. I own 2 lines that I have forgotten. Those were the particulars.
Okay. So in response to your inquiries about what had happened to Henry Katanga, what did she tell you? What did she state?
My lord,
From the first paragraph, from stating, you request that you read a statement verbatim.
my lord, Wale Katanga had this to say. I am a bomb of Bomarana. Specifically
what happened.
Yes.
Lord, I thought,
You need not to read from that.
my Lord, I think we can go specific to, since the statement is on record, we can now go specific to the events of what happened to Henry Katanga. Can I have it again? Let's begin from the second page. From I had consistently, I think.
on page 2, stated, I had been consistent in marriage. We had never had any separation. I hear that Henry Katanga died. And I learned from my lawyer I have been charged with murder.
I learned from
My lawyers that I have been charged with murder. The lawyers who informed me also Gamba Christmas. I was charged. I know that whoever charged me knows the details of my husband. Whoever charged me knows the details of how my husband died. Whether there existed a firearm at home or not. I guess the one who charged me should be able to answer all those questions. I currently know that I'm in a hospital.
questions. Currently, no.
That I'm in a hospital. I do not know how I go to the hospital.
Don't know. How?
I go to the hospital. I presume the hospital knows how I go to the hospital. I am injured, but I will not say how I sustained the injury.
I am injured.
I'm injured, but I will not say how I sustained the injury.
Yes.
I will only say how I sustained the injuries in court. I will only say how I sustained the injuries. I have an injury on my head. I have an injury on my head. The right finger, right arm, left arm. My right little finger is amputated. I have scalp is amputated. I have scar wounds on the right arm.
Wounds.
The right arm. Left arm. At our home, we stayed 6 people. I I. Youngest child is Sima Mkumba. Mutamba, Sima Mutamba. Number boy George. Jeff Nelson.
Number boy George.
Jeff Nelson. My niece, except for Georgia Nelson. The rest stayed in the main house. I and Henry shared the same bedroom.
Shared.
The same bedroom. The night in issue, I and Henry Katanga spent the night together.
Spent the night
Together.
Yes.
I don't know when I last saw him that night. The rest of the information we shall have to disclose in court. Day before, I got home in the evening. I did not come back with any person. On the day that Henry died,
Yes.
the day that Henry died, I did not call any person. I was equally never called. Here I state that whatever I must say in this matter shall be in court. That's all I can state. Statement read to me. Read up to me by my lawyer.
We should have anyone on the defense.
In the statement that you recorded, there are corrections at the name, after the name Sima, on page 1, in 2 places after the name Sima, on page 1 and on page 3. And on the name Bana Nuche. How were these corrections made?
Corrections were made amidst reading back the statement.
So what exactly happened?
When Council was reading back the statement, noted that the name Nanuche
Yes.
whereas in her narrative, she had told me that Sima's other name was Katanga. When the state
told me
that Sima's other name was Katanga.
You need to read the name of the child, my lord. My lord, do you need to read the name of the other name of the child? Since it's in the statement.
just hold it, Council.
While in the narrative, she had told me that her name was written there as
Yeah.
counsel, isn't it? As had been earlier. Then corrected. You can
Is that the position as the judge puts it?
That is where my Lord was. And that's the same position on page 3, where the same name was cancelled and another one is put just above. The eraser of that same page. For the reporter, voice quarter is followed. But is in her statement and realizing that you had made a mistake. She had made an unclear mistake of saying otherwise. Try to unquote.
What was the voice quarter?
What
She
had
had
you written?
stated,
Yes.
and I had written that except for George and Nelson, the rest stayed in the boys' quarters. When the statement was read back, she realized that George and Nelson stayed in the main house. She corrected it and it was even corrected. George and Nelson stayed in the boys' quarters and not in the main house.
That's it. My Lord, that is all from this witness.
That's my Lord. I find Rashida, would I be right to suggest that you're a senior CID officer?
Yes, my Lord.
And by recording this statement, you partly participated in the investigation.
Yes, my Lord.
Yes. And you know that as an investigating officer, make a statement, detail whatever you have done in the course of investigating a case.
Necessarily.
Sorry?
Not necessarily.
Not necessarily. All right. So, did you make a statement in this case?
I did make.
Sorry?
I did make, my Lord.
did or she did not? She didn't.
So all the events before you get to the hospital, you told her lordship are from your head.
An account of what happened, my lord.
Is that from your head?
It's not from my head. It's a memory of what transpired.
That's what you do for all the cases you investigate. You want to make statements, you simply go and pour from your memory.
I make statements depending on my role, my lord.
Now, in this case, it is your evidence that you put questions to Madame Molly.
Yes, please.
Answer to the question you put to her.
She gave me answers to the questions I put.
She accepted that she killed her husband.
So she did answer that question with an answer of either yes or no.
Go back. Continue. Push it back.
She told you she did not know how she got to the hospital, correct? That she doesn't know how she got into the hospital.
She stated so.
She told you she had been injured.
She told me she had injuries.
She told you she had been injured. She not?
She told me she had injuries.
You have the statement. Can you go to page 3?
Yes, my lord.
Second line.
Yes,
She
my
says,
lord.
I am injured.
That is correct. She said I'm injured. She did
Fine.
tell me I was
Fine,
injured.
fine. Told you that she had an injury on the head, correct?
Correct, my lord.
In fact, when you saw her, she had a bandage on her head, correct?
She had a wrap on the head, my lord.
She told you she had injuries on the right finger.
No, my lord.
Told you she had she told you that she had an injury on the head, correct?
Correct.
that she had an injury on the little right finger.
Correct, my lord.
She had an injury on the right arm
Correct, my lord.
and the left arm.
Correct, my lord.
And that her little right little finger was amputated.
Correct, my lord.
You saw that finger which had been amputated. Did you not?
It was bandaged.
She told you she had scar wounds on the right arm and the left arm, correct?
Correct, my lord.
Were both hands with bandages on?
Wherever there was.
Were both hands with bandages on? Yes or no?
Yes.
The hands, the arm.
The arm.
The arm, sorry.
The hand. The arm. The arm, my lord.
It is your evidence that after you had recorded the statement, the jet read it to her, right?
Correct, my lord.
It is also your evidence that after you had also read it to her, that Molly asked a counsel jet whether she had stated well. You say that?
Yes, we did.
Can you show where that appears in the statement?
It doesn't appear there.
You also say that counsel jet said to her that that is your statement.
Yes, my lord.
That does not appear in that statement,
It
does
doesn't
it?
appear.
I want to suggest to you that that is your own concoction.
Listen.
At the time you took this statement from her, you found her in a hospital bed.
Yes, my lord.
Did you jot down her physical condition as an investigating officer?
Not an investigating officer. Everyone was read her statement.
Yeah, but you said you actually participated as an investigating officer when you recorded her statement.
She had been examined by an independent medical team.
That
And
one I
verified
know.
her health. So my assignment was back with the medical team side.
That is not what I was asking you. You observe her physical condition.
Yes, I did. I observed her.
Did you jot it down?
No, I didn't.
Okay. Finally, from the statement, she did not know how her husband died.
Did she give an answer whether she knew or not when that person was put to her?
Please listen to the question. From this statement, right? Did not know how her husband died.
No, that is not the correct position.
She tell you she knew how her husband died.
Neither did she tell me that. But she gave me a different answer.
Please consider. Listen to questions carefully. You're a senior officer, right? Yeah. Did Molly tell you how her husband died? Yes or no?
She neither gave me a yes answer or a no answer.
Did she tell you this? I hear that Henry Katanga died. I learned from my lawyers that I have been charged with murder.
She told me that, my lord.
That gives you the information she did not know how
the question you put to me, counsel.
No, please, you are there to answer questions. You either answer the question or you say you can't answer it.
She neither gave me a yes or no answer to that question.
Never jot down the questions you put to her.
Can't they check this?
No. Please.
But they aren't part of the statement.
Consider. Listen to the question. You did not jot down the questions which you put to her.
Oh, I did.
Gambire nti ali senior CID officer kandi yatugamba nawe aketabawo mu kutolereza kyokka bwe yabe n'atolereza talina statement yonna yakozeeko kandi yatugamba biri byonna byatugambirege atakayikire airwalo agegenaabirya mu mutwe yatugamba ayina ebikaguzo byaba yenaabuza mole then mole namugarukamu then yatugamba akikaguzo ky'okuyita ibawaaye atamwereze ansa yego olundi kwabo yatugamba nti mulaka mugamba kitakumanya engeri yakire mu irwalo mulaka mugamba akabaina ebibuuta then apeegi yakusatu alanyi yakabiri akamugamba aina ebibuuta yakyora yamugamba aina ekiwuta amutwe then yamugamba aina ne bandage amukono then atamugambe nti aina ekiwuta akaara obulyo then akamugamba nti aina ekiwuta akaara kakusembayo amukono gw'obulyo nti aina nekiwuta amukono gw'obulyo na mukono gw'obumoso akaara kakusembayo ka mukono gw'obulyo kalinawo bandage. Then yachora yamugamba akaba alina kojo amikono yona. Yachora yatugamba nti bwayamazire musomeramu statement nakanso waye akachora yakisomamu. Then kyatugambire gemole yagambire nti mbalize kurungi kyo atakiandike mu statement. Then yatugamba nti akasanga mole mu irwaro kakitabu akamurora kurungi embeera yabairemu kyonka talina nali yakihandikire. Then atamugambire engeri ibawaye yafiire. Yamugambire kikaba akawura ibawaye akafa. Kyonka tamuwe ansa ikaba neyetaaga egorundi kwa kandi ekyo talina nali yakiteire mu statement.
It pleases my lord, for the record, Ellison Karuhanga. Pande Naziwa. Pande Naluze. Forgive me, Pande Naluze. Rashida. It is your evidence that Mrs. Katanga recorded you recorded Mrs. Katanga's statement on the 10th of January 2024, right? Mike, it's correct that you recorded it at 10 minutes past 5 p.m., right? Prior to recording her statement, you were in the Nakawa Chief Magistrate's Court for a hearing of her case, right?
Right.
Before you went to record her statement at hospital, did you first go to the Nakawa Chief Magistrate's Court where Mrs. Katanga's case had come up?
Right away.
On the very day of the 10th of January?
No, my lord.
Is it not true that you left Nakawa Chief Magistrate's Court with a Congo Bibiana to go to IHK?
No, my lord.
Is it? But you are aware that in fact Mrs. Katanga had been charged with murder?
Yes, my lord. At the time.
At the time you recorded her statement?
Yes, my lord.
And you're aware that she had been charged with murder, or you may not be aware, but I put it to you that she had been charged with murder on the 21st of November 2023. But you're aware that sometime in November 2023, she was charged with the murder of Henry Katanga.
I'm aware now.
At that, okay. So, but at the time you are going to record her statement, you are also aware that she had been charged with murder.
At the time of recording her statement, I was aware that she had been charged.
And it had been presented in court.
I'm not privy to that.
So it is fair to say that before Mrs. Katanga was interviewed, she was charged.
Yes, my lord. In this particular case.
Now you claim that you had attempted to record her statement sometime in November 2023, right?
Yes,
and you don't have any statement of those events, right? You don't. You don't even have the date on which you attempted to allegedly record this statement, right?
I don't have it.
Thank you. Thank you. You don't have the name of the hospital attendant that you found. In fact, you have no record. Much obliged. Much obliged. Much obliged. In fact, there's no record of you even attempting to visit or speak to Mrs. Katanga, right? There is no record before this court of your visit, alleged visit in November 2023, right? Is it in this court? Is it before this court?
No, my lord.
It was your evidence that Mrs. Katanga had been examined by a team of independent medical officers, right?
Yes, my lord.
They said, and I'm putting this to you, that this is what they said, that Mrs. Katanga is a 53-year-old lady admitted in Care Hospital on 2nd of November who had suffered multiple scalp lacerations, fractures involving both her upper limbs, was in hypervolemic shock. She's alert and coherent but has dizziness. Sorry, my lord. They stated that Mrs. Katanga is a 53-year-old lady admitted in Care Hospital on the 2nd of November 2023. And had suffered multiple scalp lacerations, fractures involving both her upper limbs, and was in hypovolemic shock, which is HYPOVOLEMIC. She is still undergoing medical treatment. A statement can be obtained from the patient while in hospital, and that she has undergone a number of surgeries, the last being a scalp debridement done on the 12th of December 2023. Is that what they said?
I don't know what they say. I was only given a deduction from what the doctor said. I received information from the senior commissioner of police.
So you only told that you can record the statement from her while in her hospital bed.
Exactly.
And this medical examination, you are aware, had been conducted by the Ministry of Health.
I don't know, my lord.
So the only thing you know is that a medical examination had been conducted, allowing you to record her statement from her hospital bed.
That is what I know.
My lord, that is it from me. And my lord, I've consulted with my learned friends. We'll be withdrawing our objection. No. Okay, maybe.
Let's finish it. Let's finish it. My lord, if there is any re-examination.
Sorry, apologies. I withdraw the withdrawal.
What you're supposed to do.
I've forgotten what he's supposed to do.
My lord, there is no real answer from us.
No.
Not today, my lord. My lord, the record should reflect Katanga is
No, my lord, no, my lord, Mr. Kawats will address court.
Yes, I think we are through with this.
Tugambire nti statement recording ebiro 10 January 2024 tukaba bwire bwa saa 10 dakika 10 yatugamba nti gali mazima nti kirekyo akasooka yaba nakawa akoti ya nakawa yatugamba kandi atarugeyo na akongidiana akaba nakimanya mole katanga bakabani bamutunana omusango okwita kandi yatugamba nti China statement yona ya November ya 2023 kandi yatugamba takujuka ebiro byokwezi nti China neibara bya dokita ayabakozero mu irwaro nti kandi tusakiandika ekikolekya nti akabungirawo mole katanga mu irwaro mu November ya 2023 wekyakumanya badaktari bakasooka bamukebera nti bwe bamazire bamugamba akusobola kwijja namuyawo statement akitabo wekyakumanya oba tukakolebwa abaministry y'obumezi
My Lord, given the fact that this witness, Peter knew has in any case fully testified, and in the interest of the position of this trial, we've considered the need to go through some measures regarding non-disclosure for the witness testified. And our view is that whatever the outcome, in any case, there will be still no consequence. So accordingly, we are abandoning that objection. Can only have the effect of robbing us more time. But we would pray that if they have other witnesses whose statements have not been disclosed to us, they should disclose them to us. In the interest of fair trial. Accordingly, my Lord, since the prosecution is not able to read another witness today, put adjourned to Tuesday for onward hearing of the trial.
Take it. Don't take the money. Much obliged.
My Lord, because the record must reflect well. Just a brief concern with a statement that Council Kavasi has just made. My Lord, it should not be that the withdrawal of the objection is just because it is in the interest of time. Because a legal objection, we want to believe, and the withdrawal should reflect that it is because they have reconsidered that it lacks merit.
No. But she has testified already.
When you withdraw, you can give your reasons.
We can give our submissions, nevertheless.
Because, my Lord, time can never be an impediment to the justice-seeking process.
No, it's not only the time, it's that she has already fully testified.
Mr. Kavasi, you talk to me.
Yes.
Let's give reasons for our withdrawal.
Secondly, my Lord, the best of our stand as of now, we are confident that we have disclosed all the statements that must be disclosed. And should anything, my Lord, come up to our knowledge that has not been disclosed, we shall courteously bring it to the attention of our land colleagues of the press and to the notice of court.
are coming back on the 30th of this month for another witness. This is the media. If you have been on, just do the doable, subscribe, make it happen. Yeah, the court is done. We shall be getting some interviews to come any time from now. But for now, we call it a day. It is here at the High Court. Probably we shall be getting here next. We shall be getting here 30th of this very month. But we call it a day for now. Thank you for subscribing. Thank you for following up. In case you are still on subscribe, just in case you have not yet subscribed, subscribe to the channel, make it happen. It is me, yours truly, MC David Hart. Subscribe to the channel if you are not yet subscribed, and we make it happen. It is the Heavy Media. We shall be joining on 30th of this very month. I think it will be a Tuesday. I'm not so certain which day is going to be, but we shall be getting here back right away. Thank you for following up. It is yours truly, Heavy Media. Yours truly, Musa Sankambo, aka. Keep it up, keep it up, keep watching. We shall be getting up next time from now. Otherwise, I want to say bye bye to all of you, my viewers. Have a blessed weekend. It's going to be Friday tomorrow. We don't know whether